Hello, you guys. Oh, hold on. One second. Hello, you guys. Good afternoon. Hopefully, you guys can hear me okay. I hope you all had a good day. It's a work day, or generally a work day for most people. So, I hope you all had a very good work day. I hope you had time for your breakfast, for your lunch. Right now, I just came out to Starbucks to grab me a chai tea latte. So, y'all know I like to come talk to you guys when I am doing my midday run or whatever it is I'm doing, right? So I wanted to come talk to you guys because last night I tuned into Lady D to watch her read the motion Bo Burnley put in for R. Kelly responding to the government. From what I understand, I don't know if this is right order. I think now that this is a determination that's going to come from the judge. I don't know if the government has a right to respond after this motion or if this is the final response. Hey Miller, hey boo. Thank you. Yes, I had a good time with you yesterday. Um, but today I wanted to come on and speak about the motion with R. Kelly because I have some questions and I know other people are gonna go live. And if anybody else is watching, or maybe anybody who's watching my channel who does go into some of these chats, maybe they can get the answers to some of these questions, right? Because I have some questions from this motion, right? So I was listening to Lady D last night and I think I chose to listen to her because she was the most palatable one out of um the situation that was reading it last night. I like Lady D. I think Lady D is very cute, right? And Lord, Lady D sounded like she was a church lady, like reading that motion. Poor thing. She sounded like a church lady reading that motion. I think she was just excited for the fact that for once something was turned in and it was turned in on time. It met the deadline, right? And so Lady D read the motion last night. Y'all can go to her channel and I think it was only like 20 minutes or so of a video without all of the extra, right? Without all of the name calling and bashing and all of that. She read the motion. She read the motion for what it was. She gave her opinion and then she moved on, right? And so I thought that's what I could do. That's what I was able to tolerate last night because I didn't want my blood pressure to start going up, right? So Lady D read the motion. And immediately, as soon as the motion got started, I put my hand in my head because I was like, oh Lord, oh Lord. Because y'all, this is just my opinion based on me listening to the entirety of the motion she read last night. A lot of that motion is stuff that I done heard say out here on this YouTube street. And so that's why I'm confused. I want to see what is going to be the colorful picture painted when people start to give their commentary on the motion being submitted, right? I'm curious and I'm interested. I also want to be honest, I am interested to see them actually give him an evidentiary hearing to determine this new evidence that they are suggesting that they have to present, because I'm interested to see what the evidence is, because based on what we've been hearing out here on these YouTube streets, I kind of know like maybe some of what might be presented. And I actually want to see that presented in court. I do. I want to see an attempt be made to present some of these scenarios and situations and theories and hypotheses into the court, right? So I'm actually interested to see it. I would love to see this play out in the evidentiary hearing, right? So one of the main things inside of like I said, go to Lady D's live in order. I can't play it for you guys right now because like I said, I'm on a move. But I wanted to get this out, like I said, before other people start to do their commentary or other people start to read it. Like I said, in case some of you guys who come in to listen to me go into the chat to interact with some of those people in those communities, because I want to I like I said, I have some questions, and I think that they are questions that stay on point, on target, on the subject, on the content, right? And based on what I've seen like presented out here, I question some of the things that were presented in the motion, whether or not it's actually new evidence. And that's based on what I've seen some of the things presented out here by various people who are in favor and who support R. Kelly, right? So one thing that was mentioned in the motion by Bo Brindley was that the state inferred that or the government inferred, because in this case it's the federal government, that the government first of all, before I go there, let's rewind and let's go back. So I have another question that I would love answered, right? Because I hear so many people like focus in on this RICO and them feeling like, okay, the reason why we joined this fight was because we don't think that this RICO was justified. We don't think that based on the behaviors, based on the allegations, that the RICO is what is justified. So my question then becomes, because from my understanding, this is a motion for a new trial in the Chicago trial. So my question then becomes, how does that justification for your fight hold up against the Chicago trial? Because in the Chicago trial, there is no RICO. That's not part of the charges. So if the main purpose of the fight is that you don't agree with the RICO, you felt like it was excessive, you felt like it was too aggressive, right? What is the base for the Chicago fight? Because there's no RICO. There's no RICO charge in the Chicago case. So if your main basis is that you don't think that the RICO is justified, what is your justification for the Chicago charges, for the Chicago conviction, right? So that's one thing I would love to be answered, right? In all sincerity, right? Before we even get started on before I get even started on my questions about the motion, right? So my questions in the motion, Bo Brindley outlines that there was in the previous motion response from the state to his initial request for a new trial, that the state infers that the attempt to flip the witness and use these coercive methods to do so that are considered, I guess they're saying were considered like illegal to do, criminal to do, shouldn't have been done, right? That they did this, they're saying that the government is going off of the theory and the assumption that it started after R. Kelly was incarcerated. But their theory expands and this reaches further, and it goes back to before R. Kelly was incarcerated, right? And so that left me like slightly confused, because when in the initial request and from what I heard, I remember it being said that there was a meeting in California where these methods and tactics were used in order to flip this witness. So in my opinion, I think that might be why the government used this like as a starting point, right? I don't think that that was something that was presented by the government. I think that was presented by Bo Brindley and his team, right? Or at least that's what I got from what was initially submitted and what was initially released in that press conference. So if it started before R. Kelly was incarcerated, I'm trying to figure out how these documents that were obtained illegally have anything to do with what they are alleging. Like I'm kind of confused about that, right? So I'm interested to see like how they will bring that together. I'm interested in other people's theories about how they are going to bring that together, because if they are suggesting part of the government's response was that Rashona Landfair was on board to testify even prior to what the theory of the defense team had submitted, right? So now the defense team is saying that no, that the government has that wrong. They are under the assumption that we are saying that this process started when our client R. Kelly was incarcerated. That is not what we are suggesting. This whole thing started even before he was incarcerated, right? And so my question then becomes, if the witness had already decided that she was going to testify prior to him in his incarceration, what did these documents that were acquired by the BOP illegally have to do with her coercion, with the coercion on the part of the government, right? That has me like a little confused. I want to see what trick out of the magic hat is gonna, like, they're gonna come up with that, right? How are you gonna explain that? Because the allegation is that the meeting in California is what caused the flip, and that meeting was a disclosure of things that were acquired while Mr. Kelly was incarcerated, and then the meeting of the two Jane Does, Jane Doe number 5 in New York, and then that Jane Doe number 1 in Chicago. So if that is the case, how do you now go back and say this whole process started and initiated before that? When I guess I think you kind of gotta say that, because the witness is confirming publicly that she's making a public proclamation that she agreed to testify even before Mr. Kelly was incarcerated. So it creates an issue for the timeline. So that was one thing that I was confused about. I would like to know if somebody can try to provide some insight to that and clear that up, and provide us, the community, with some more details and their theories and what they think about that, right? The second thing I noticed in the documents is that it's a reason I got my thumbnail that say the two witnesses, right? So anybody who is familiar with apocalyptic scriptures, right, they know that I got that from that, right? So the apocalyptic scriptures talk about these two witnesses that in the end of days will be at the Wailing Wall. They will be unalived at the Wailing Wall, and then they will raise again in 3 days. But they are going to be there basically giving public proclamations of the impending doom and Jesus's return. I mean, the return and Armageddon and all of these different things. All of these different things about the apocalyptic message, right? And so last night when I was listening to the part of the motion where they talked about having witnesses that corroborate the coercion, the illegal tactics used by the federal government, it made me think about that, right? It made me think about these two witnesses at the Wailing Wall, because there's always like this speculation on who those two witnesses are. There are some people, and you have some Bible scholars and theologians who will say that those two witnesses are going to be Moses and Elisha, right? But we don't know. It does not say, right? And so I then had this same poignant question when thinking about who are these witnesses that they are alleging they are going to be able to come and give testimony that the government did something illegal when acquiring and agreement for the victim witness to testify. Who are these people? Who is coming forward? And I guess my main question is, should something have accompanied that in order when submitting the request for a new trial? Because shouldn't there be something to motivate the judge to say, yes, we need a new trial? Like, should there be some type of signed affidavits? Should there be some presentation of who these witnesses are? Like, I don't know. And that's why I'm asking the question. Like, what should that, just a mere statement in the motion, is that enough to get a judge to grant an evidentiary hearing or the request for a new trial? Should there be something that is accompanying the motion that lets the judge know we have these people on deck, right? We have no other information other than there are witnesses that exist. Now, it doesn't say two. I just got two witnesses on there because that's what the biblical prophecy says, right? And I thought it made me think of that when I was thinking about when I heard that part, right, of the motion. But we don't know how many witnesses is claiming that there are, right? They just claim that there are these witnesses who can corroborate that there was some illegal tactics used by the government in order to get this victim witness testimony, right? And in the back of my mind, I'm like, okay, is that it? Is there something that is accompanying that? Like maybe when Lady D was reading it, was it a link to something that provided some attached documents or something to let us know who these people are, what they are alleging happened? Because there is no clear picture on what, and that I'm going to get into that too, but there is no clear picture on what these tactics were from that motion, right? We still are left with a lot of uncertainty from the motion. And I know the evidentiary hearing would present the evidence towards it, but I want to know, should there be something more at this stage that was presented in order to persuade the judge to a evidentiary hearing? That's a question I have, right? Is the mere fact of stating it in the motion enough to persuade the judge to move forward with an evidentiary hearing? So that's another question I have. Like I said, I don't know who they claim these witnesses are, but then there was another thing surrounding the fact about these witnesses that I thought was interesting. So from the original request, there were statements made that the victim witness was actually prepared to give an affidavit and testify to these facts. This new evidence that was discoverable, that was newly discovered, right? But now the new response to the government doesn't mention anything about having the victim witness as a witness. So I found that interesting. I saw that switch, that gear switch, you know. There's nothing mentioned about the actual victim witness who they originally alleged that they had on deck, that she was willing to testify. That's no longer part of this motion. They are solely relying on the testimony of these witnesses who witnessed or who have something to offer in order to substantiate the claim of what the government did illegally to acquire this witness's testimony, right? So I found that interesting. The next thing I found interesting is that I should have wrote this down and put it somewhere because I'm trying to remember. The next thing that I found interesting about the motion, hold on, y'all. I just did a blank because it was right on the tip of my tongue. I don't know how I just drew a blank like that. Like I got fog brain really quick. Hold on. The witnesses. Oh, okay. So there were two things. Hey, Queen Kish. Hey, Boo. So I'm talking about the motion that came out. Bo Brindley finally entered the motion and the request for a new trial on time. And so I don't know where we are, like I said, in the steps in the process. I don't know if this is the last response before the judge makes a ruling on it, or if the government has an opportunity to respond again. I don't know, but he responded to the government's response, and now we are waiting, I guess, what happens next, right? So Lady D, she was the most palatable of them all for me to listen to about this motion. So I listened to her last night. It's a 20-minute video, approximately 20-minute video that she did reading the motion. And so I just had some questions about the motion. This is the Chicago trial. So he's asking for a new trial, right? And he's asking for, I guess, an evidentiary hearing in order to show that there's new evidence that would suggest that there be a new trial. And so that's what I'm about to go into now. I'm glad you came in here because now you jog my memory. So it's about the new evidence. You can go back to after I'm done, you can just go back to the beginning to find out the first two things that I mentioned in relation to the motion, right? That he filed last night. But you sparked my memory about the evidence, the new evidence, right? So one of the things that is mentioned in relation to new evidence is that the jury was not made aware of promises that were made to the victim witness, Jane Doe number 1, right? That's one piece. That's one piece of new evidence, or at least from what I saw from the motion. This is what I interpreted it, that this is somehow there is something in relation to some promises made to the victim witnesses. To the victim witness, and it not being disclosed to the jury. And had this information been disclosed to the jury, then it could have impacted the outcome of the trial, right? Well, this is the question I have, and this is what I mean when I said, from me watching most of the content creators in the R. Kelly sector, I'm only going off of what I've read myself and then what they also have read, right? Yes, on Rashona, right. So I have read over and over again the area of the transcript where Rashona is questioned about was she told she could receive restitution. There is an exchange between her and Bonjean about that in the transcript in front of the jury. So if there are some other promises, I'm interested to know what were those other promises that they are alleging that were promised to her on behalf of the government for her testimony that the jury was not made aware of. Because from my recollection, from my going back and previewing what has been said in the transcript, from me having read that portion of the transcript, it was disclosure to the jury that she had an opportunity to seek restitution. And there was some questioning about the ambiguity of her seeking that restitution. And it was used, from what I saw, Bonjean used it to the advantage to say, at first you made it seem like this wasn't about you getting any money. Now, all of a sudden, last minute, you put in this application for restitution. And so this was disclosed to the jury from my recollection and my understanding. So if there was some additional promises that were made to the jury that is new evidence, that weren't disclosed to the jury, that is new evidence, I'm interested to know what were those things and how they plan to prove it. You said, I thought it was going to be evidence. It wasn't her. This all they got. Yeah, I don't know, because I guess once the book came, I don't know if it was ever a plan to say it wasn't her on the behalf of his legal team. I don't know. I don't know what, at this point, I don't know what the legal team is thinking, because I'm telling y'all, Queen Keisha Miller, this motion sounds like everything I've heard these people out here saying. That's what it sounds like to me, right? And so, I don't know if there was, if the strategy is to present something to say that none of those videos were her, because we keep hearing out here about this one particular video, but there are several videos submitted into evidence that she is on. And my question is, are you just are they focusing on one video? Are they questioning all the videos? And where, if that's the case, why wasn't that challenged initially? Those videos were available at the time of the trial. So why wasn't it initially challenged by his legal team at that time? So I don't even know if that is even something that can be brought into or submitted. This is why, Queen Keish, I'm here asking these questions. So hopefully, like when you guys, y'all go out to, because I'm pretty sure that there's going to be more commentary surrounding this in the next couple of days with Intersector. When you guys go out into those different chats, maybe y'all have some of the questions, and maybe us having this conversation here will remind you to ask these questions inside of the chat and then maybe there are people who can provide the answers, right? But these are some of my questions. Like, if there was a challenge, the motion to me doesn't mention, from my understanding, doesn't mention anything about challenging her being the person in the video evidence that was submitted with her in it, right? But we have heard that. And so I'm interested to know, do they think that this is going to be part of the new evidence? If so, I didn't hear that mentioned in the motion. You said, so if he gets off on Chicago, he still has a New York trial doing 30 years. Yeah, what happened to Bonjean? Did she quit? I know that Bonjean is off of the Chicago case. If I'm not mistaken, I think she is also off of the New York case. And I don't know if she's still handling whatever civil matters that may be out there or whatever. I don't know. But for a fact, we know that Bonjean is off of this Chicago case, right? So, but like I said, I'm interested in knowing what they are suggesting that she was promised that was not disclosed when she was questioned about receiving restitution. To me, that line of questioning would be a disclosure to the jury that there was something that she could have potentially gained from her testimony. And so what is the new evidence? What is the new thing that is now saying that he should be entitled to a new trial based on something she was promised? I haven't heard anything out here other than the same things that have been presented. And to me, that was disclosed in the transcript. It's been read several times over and over again. So I'm kind of confused at how this becomes new evidence, right? I would love that explained. But the second thing that I would like to get some understanding on is there was mentioned in the motion that there were threats made to her family. You said find time when she comes out with with a book. He's better off saying that wasn't him and he was fooled. She's going to have to retest. Yeah, if they granted a new trial, yes. You know, right now I think they are requesting that an evidentiary hearing take place to determine the outcome, to give a decision on the new trial. And but like I said, I'm confused. Like, to me, I thought with this motion that there should be something more substantive submitted with the motion so that the judge can determine if they should move forward with evidentiary hearing. And based on the reading of it last night, unless Lady D omitted the hyperlink saying that there was something submitted, it didn't look like nothing was submitted along with it to show any proof to the judge why, yeah, we actually have this evidence and we would like the opportunity to present it, right? And from what I understand, I thought that's what's supposed to happen. So I would like more understanding on that, right? So then there was another mention in the motion, like I said, of threats being made, like as if the government made threats threaten her family, right? So immediately I'm like, okay, well, what was the threat to our family? The threat to the family was that they could be locked up for lying in the first trial. They could have been charged. So they were granted immunity, right? Well, the problem with saying that that's new evidence is that was also disclosed to the jury. Because if I remember correctly in the transcript, when Rashona's mother is on the stand, I believe that the prosecution is the one who first made and alerted the jury that she was given some type of immunity. I don't think it was, I believe that the defense might have questioned her on it, but if I'm not sure, I think the first mention was by the prosecution. So that was disclosed to the jury. And that basically the motion is saying, based on these things, this new evidence, that this could have changed the outcome of the jury's decision. But these things were disclosed. And so I'm trying to figure out, what are they suggesting is the new evidence when it comes to threats made to her family. And so the only other thing I could think of that I've heard out here when it comes to the new evidence on her family is that it has been floated out here and said that something was done to her father to unalive him. And I am like, what is the evidence? That's why I said I want this to go to a evidentiary hearing, because I want to see what evidence is possibly going to be presented to suggest and prove that type of thing to get a new hearing like this. I know that's not the new evidence, y'all. I know it's not. Like, it's got to be something else. But at this point, I'm curious to see what is the new evidence. And then if that is the thing, that is some type of chemical or biological weapon that was used to unalive Rashona's father, and then this is what scared her and her mother into testifying on the stand, where is the proof? Where is the proof of that? How are you going to prove that? I am really interested to see this play out in the evidentiary hearing to see how that is going to be proven. Because I've heard it said, I haven't seen nothing giving no proof to it. They have to convince the judge of this. What do they have to convince the judge of that kind of claim? So I am very interested, and I hope the judge grants an evidentiary hearing, because I am curious to see if what's going to be submitted. You said no matter she was threatened, she still was with him at very young age. He should have been found guilty first trial. You said the judge will throw. I listen, Queen Keish, if you want, listen, I can give my honest opinion, right? My honest opinion is that this is getting thrown in the trash. That's my honest opinion. And last night, Lady D was so excited. She was so excited, Lord. She, like I said, she was like a church lady on Sunday morning. I think most of her excitement came from the fact, like I said, that something was actually turned in on time by him. But when I listen to this motion, I'm like, I think this is getting thrown in the garbage. But I am interested. I would love to see an evidentiary hearing play out, because I want to see what is this new evidence, and if my predictions about what I think that they are claiming are correct. And if so, how that will play out in the court. Because I am not a lawyer. I am not a paralegal. I am not none of those things. So I don't know exactly how it's going to play out in court. I'm only giving my opinion as a regular human person that is trying to use my regular common sense. And based on what I seen presented out here, and based on what I heard in that motion, I don't see any new evidence. I don't see any new evidence. I don't see any proof of any new evidence that would substantiate a new trial in the Chicago case. I don't. You said, Queen Keisha said, it's better off and only listening to you. His fans don't make sense. I'm not a fan anymore. I believe he was with Rashona and Aaliyah for sure. I believe all of that too. Queen Keish, I do too. And that's why I asked the question at the beginning of this that I asked is that even if those who said they were fighting because they didn't agree with the RICO charge, how does that hold up on the Chicago case? Because there is no RICO charge in the Chicago case. So what is your reason for your fight in the Chicago case? The reason for your fight in the Chicago case would have to have something to do with the evidence, because it's no RICO. So that would be no excuse or reason to say we don't agree with the charges, because there's no RICO present. So in order for you to still be in the fight in the case in Chicago, it would have to have something to do with you having issues with the evidence that's being presented. what you say, Queen? You said that case won't get thrown out. He have to do 85% at least, which is 17 years, right? Do you think he needs to get 20 and 30 years? So this is the thing, Queen Keish. When I, especially in the beginning, right? And even some now, I can see why people think that the RICO is excessive, right? I can see why people think that. Because when you are not used to seeing a RICO built this way, then you would think that it was excessive, right? And but then I had to like rethink that, right? As I was thinking it out, right? Over time. And over time, I had to think of the level of sophistication of how he was avoiding being caught doing what he was doing. And that is what RICO is for. A RICO is for a sophisticated network. It is to catch people who have built a sophisticated network to where they cannot get caught on certain crimes. They continue to get away with this pattern of behavior. And so that law was created in order. Now, like I said, because people have not seen it traditionally built this way, they don't identify with it in this manner. But I think this was the level of sophistication that the government felt like they needed to go to in order to stop the pattern of activity. That's their goal. Like, in our mind, like I said, we can think, okay, this was too much. It was excessive, right? We've never seen. We can think that. But I think that when we think about it, like if we were to try to be honest on all sides of the fence, we can see how the government will come to a conclusion that this is the way for us to stop what we see as a predator that is participating in predatory behavior. And so in order for us to deal with the level of sophistication of his crimes, we have to come up with a sophisticated method. And I think that the RICO was a sophisticated way to attack the situation. And that's why I kept saying, like, the more sophisticated that you get with the crime, the more sophisticated that the government is going to get at trying to figure out how to get you for it. What did you say, Queen? You said he's a repeat offender. It's why he got so much time. He would have got only 7 to 10 first trial. He would have been out. That's what I'm saying. Like, if in the first trial, some of the things that were done were not done, right? Then maybe it would not have allowed his network to become as sophisticated as it became. And then maybe he would have went in, learned his lesson, or whatever they would have given him for it, and then it wouldn't have resulted in this. But over time, as you become more sophisticated with getting away with the crimes, then you have to expect that the government is going to become more sophisticated at how to get you when they've been made aware that you've committed the crime. And I don't think that is something that we should think is unreasonable for the government to do. That's the business and that's the job that they have to do, right? And so whereas we can think that it's excessive, I don't know. I don't think at this point, Queen Keish, I don't think I have an opinion on how much time he got one way or the other, right? Like this is how I feel about it, Queen Keish. If there was some way for him to be granted some relief that I felt like was legitimate because it didn't require him to people to lie and do a whole bunch of other things, right? Then I'm okay. If that's the law allows him, that's what the law allows, right? But am I satisfied with what the government did? Yeah, I think it's one way or the other. I think as long as there's some remedy that his legal team could find that would not have all of these lies, all this mischief and mayhem and all of this stuff, I think it would be able to settle better with me. But I think it's all of the stuff that is surrounding what is what they're trying to do. I think that's what I have the issue with. Really. You said he was set to get Jerronda right outside the first trial. He was so arrogant with it and believed if he sent Joycelyn home, the judge will have more sympathy for him. I don't know. I mean, yet possibly, but I don't know. I don't know. The judge might have still, even with Joycelyn going home, the judge might have still, came down the way that she did, especially in New York, right? The New York judge, right? She, especially her, but the Chicago judge says that if it hadn't been for the New York trial, and if Kelce had been convicted only on the Chicago, if the Chicago case had been first, he would have given him more than what he gave him. But then, like I said, you had people out here who are suggesting that the judge didn't believe the victims in the Chicago trial and that he didn't take them serious and all this other stuff. But it is on record that he says he would have given him more time if it had not been for the time that he received in the New York case. So that's my question is, okay, so even if you take away the New York case with the RICO, which is why some of the people say that they rallied for out here, what about the Chicago trial where there is no RICO? What is your intent? What was the purpose? What is your reasoning for rallying in that one? The only reason would have to be that you find something wrong with the evidence. And so I'm curious to know, what do you think is wrong with the evidence? And if you think that what's wrong with the evidence is that the audio and video is not him, why wasn't that challenged by his legal team? And why is that something that is not being challenged when we are looking at this appeal process or these requests for a new trial or a request for evidence? Why is that not being presented? Like, we're still not seeing that being part of the presentation. And so that's really my questions. But if my overall opinion on what I think, or let me say prediction based on my opinion, this is going to be thrown in the trash. If they want me to get more frank of what I think about this motion, I think I might get in trouble for saying this. I don't know. This my opinion though. This is my opinion. I think they got on Bo Brinley nerves, calling over there, doing all that fucking bullshit. I think he slapped some shit up in there to satisfy the people. And I think he knows this ain't going nowhere. Because, like I said, where is the proof? What is the product? What is the proof of these things? I don't know. But that's just my opinion. And it's a layperson's opinion. I don't have my opinion doesn't have any more weight than anybody else that's floating these theories out here. But my opinion is that these people then got on his nerves, calling over there to their law office. He then gave them what it is that they wanted in submitting this motion, because I think that he knows that none of this is going nowhere, and I don't think it's going nowhere, but the judge is going to say denied, and I think that's going to be the outcome. I know there might be some other people who have some other reactions but that's my opinion, and that's my reaction to what I heard Lady D read with the motion last night. Now, I am very interested to see what other colorful narratives everybody will come out with from this, right? My ears are open. I am listening. Like I said, I'm interested to know whether or not there was any documents or things supporting if there was any type of supporting documents that were submitted with this motion that would persuade the judge towards having an evidentiary hearing. I would like to know if that would have been best to have done to persuade the judge. Is saying that you have it enough? Because they told us that they had something from the victim witness. Now we're not hearing a mention of that in the new motion. So is just stating that you got these witnesses that witnessed these things occur enough? Does there need to be something that's supporting that these things occurred in order for the judge to make a ruling on the evidence? Not to make a ruling, because he can make a ruling to deny it if it wasn't presented. But is it enough to persuade him to rule in the favor of the defense for an evidentiary hearing? Like, I really, that's one of my main questions. Is there something more that should have been presented with this, as far as documentation, to persuade the judge towards the evidentiary hearing? Or is it sufficient? Is saying it sufficient? I don't know. I'm interested to see. But like I said, I would be very much interested to see this move forward with an evidentiary hearing, because I want to see what new evidence is being claimed to have been acquired. And based on what I heard in the motion, to me, none of that is new evidence. And the only new evidence that I've heard floated out here, potentially, is unaliving of Rishon Land Fair's father on the behalf of the government. And I want to know, what is the proof of that? Just saying that is not enough. What proof is going to be provided to prove that, to persuade the judge that there needs to be a new hearing? The allegation alone doesn't stand without any proof. So I don't know. I'm just a person that I just have questions. Those are some of the questions I had from when I listened to that motion last night. And I wanted to come and talk to y'all about it real quick while I came out here to come get my chai tea. And Queen Keisha, thank you for coming here and talking to me. Bella, thank you for coming here and talking to me. I love y'all. Just V, if you catch this live, I just skip all through the live. Just skip. I know I waited to the end to say it, but just skip through the live. It's about R. Kelly. I know you don't want to hear it. The only reason why I'm coming, because it's a motion that came through last night and I just had questions. I just want to know. I love y'all. Y'all have a good day, and I will talk to you soon. Peace.